The Bobby O Show.
Welcome to the Bobby O Show. My name is Bob O. Potzner. I'm an attorney from Danbury, Connecticut. And if you love sports, especially college sports, you're going to really enjoy today's show with one of the experts in the world on a concept known as name, image, and likeness. And we'll get to my guest in a few moments. But before I start that, I want to go to another topic that is very important and is very near and dear to my heart. As an attorney, I'm a member of the American Bar Association. It's a national organization, and the president of the ABA, we call it, William A. Bay, wrote this statement, which I want to read to the audience because it's my way of supporting the rule of law. And that's why you see on my stand, it says, Attorney Bob Potzner, I stand for the rule of law. The government has decided to punish a prominent Washington, D.C. law firm because it represents a party that the administration does not like. There are also reports that actions may be taken against more law firms. Clients have the right to have access to their lawyer without interference by the government. Lawyers must be free to represent clients and perform their ethical duty without fear of retribution. These government actions denies clients access to justice and betrays our fundamental values. We, the American Bar Association and the lawyers, support the rights of people to advance their interests in courts of law when they have been wronged. We reject the notion that the government can punish lawyers who represent certain clients or punish judges who will rule certain ways. We cannot accept government actions that seek to tip the scales of justice in this manner. We speak today on behalf of the legal profession and its members who seek to live by the oath each took upon admission to the bar. This is not something we do lightly, nor is the first time we have spoken in opposition to action against an administration, regardless of political party. We sued or opposed policy proposals of the last few administrations when they failed to adhere to the rule of law or interfere with access to justice, and we are doing the same with the current administration. We are nonpartisan. We stand for the rule of law. We stand for the vital role of our courts and the essential job that lawyers do every day throughout our country. We have stood on this ground for many years. We reject efforts to undermine the courts and the profession. We will not stay silent in the face of efforts to remake the legal profession into something that rewards those who agree with the government and punishes those who do not. Words and actions matter, and the intimidating words and actions we have heard must end. They're designed to cow our country's judges, our country's courts, and our legal profession. Consistent with the Chief Justice's report, these efforts cannot be sanctioned or normalized. There are clear choices facing our profession. We can choose to remain silent and allow these acts to continue, or we can stand for the rule of law and the values we hold dear. We call upon the entire profession, including lawyers who served in elected positions, to speak out against intimidation. We acknowledge that there are risks to standing up and addressing these important issues, but if the ABA and lawyers do not speak, who will speak for the organized bar? Who will speak for the judiciary? Who will protect our justice system? And if we don't speak now, when will we speak? The ABA has chosen to stand and speak. Now is the time for all of us to speak with one voice. We invite you to stand with us. Reading this statement is my effort as a former elected official, 15 years on our Board of Education. I believe strongly in the rule of law, as I'm sure my guest, Len Simon, does as well. Now we can get to the purpose of today's show, the theme of today's show. I'm going to introduce to you Len Simon, an attorney from San Diego, California. Hi, Len.
Good morning.
How are you, sir?
I'm fine, and I agree wholeheartedly with the statement that you just read from the ABA.
Thank you so much, sir. I really appreciate it. Len, tell us a little about your background, please, before we get into the topic of NIL.
Sure. I'm a lawyer. I was born in Hartford, Connecticut. I went to Union College in Schenectady, New York. Duke Law School in Durham, North Carolina. I'm wearing a Duke tie in honor of us being in March and Duke having a pretty strong team this year. And in the course of law school, I created a course called Sports and the Law, created out of whole cloth. It didn't really exist anywhere. And I continued to, I would say, experiment in getting sports into my law practice. It's always been 5 or 10 or 15% of my work, never the majority of my work. But I've represented Major League Baseball, the San Diego Padres. I've sued the NFL, the NCAA, National Women's Soccer League, and I've represented athletes, agents, high school girls who wanted a better softball field under Title IX, and the like. I live in San Diego, California, lived in Washington, D.C. for a few years, but have been out in San Diego for 40 years. I worked with a law firm called Robbins Geller for many years, and now I am still vaguely associated with them in my 70s, but spend a lot of time doing what I want to do in my own one-man law firm, and a lot of that is relating to the sports world.
Len, you and I both went to Duke Law School. You went a few years ahead of me. It just hit me that there was a professor I had for contracts law named John Wiestar, who, as I recall, wrote a book on sports law way back in the mid-'70s. Did you ever have John Wiestar as a professor?
Yeah, John Wiestar is the person who we had to solicit or recruit to be the faculty advisor to our ad hoc seminar on sports law. You could have a course on anything you wanted at Duke Law School for one credit, student organized, up to 15 students or maybe minimum 15 students. But the only restriction was you had to find a professor who was willing to coordinate it, not teach it, just coordinate it and conclude that it had some academic value. And we approached John Wiestar. He said he would do it. And 3 years later, he had a book out on sports law. So I called him and asked him where my check was for my share of the book proceeds, and he just sort of chuckled. But yeah, he was one of the first people in the field in terms of law school faculty.
He was one of the best professors I ever had in college or law school. In fact, I still to this day can remember the first time he called on me for the entire class and drilled me on the mailbox rule. And he's a great guy. Len, tell us a little bit about what is NIL. Okay,
let's talk about, if we can, two things at the same time. Let's talk about amateurism and NIL. The battles that have been going on between the NCAA and the athletes who play in NCAA schools and the public, which mostly sides with the athletes for the last 5, 10, 12, 15 years, have been about whether the athletes can obtain compensation of any kind for their athletic activities. The rule has been in the NCAA for decades and decades that you can get a scholarship, room, board, books, tuition, $15 in what they used to call laundry money, incidental money, or whatever. And beyond that full scholarship, which is quite a valuable thing to get, you could not be given anything by anyone. And that's important to stick with the by anyone here. You couldn't be given anything by anyone because you were an athlete or because you were a star athlete or because you won a championship. And the reason for this was that the NCAA had decided that college athletes should be amateurs. Those of you with a good memory and who've been around a few decades remember that used to be the rule in the Olympics. You had to be an amateur to compete in the Olympics. And Jim Thorpe had his medals taken away years after he earned them because he was a professional. And there were a lot of young people who came out of college who were track and field stars or tennis stars, golf stars, and had to decide, did they want to compete in the Olympics, in which case they had to not take money, or did they want to earn a living, start a family, and move on, in which case they needed to skip the Olympics. College was the same way. If you wanted to make money, you couldn't go to college. Now, there are two ways to make money, maybe three, when you're a college athlete, particularly a star. You can get paid by the university, but that has been completely prohibited for decades and decades and decades. You can get money under the table. It's always been rumored that a good football player recruited to Alabama will get a bag full of $100 bills from a bunch of alumni who want them to go to Alabama. So if you count illegal means, we can get up to 2. But the third way is, of course, you could have a contract with Nike. Assume you're Michael Jordan. Assume you're LeBron James. Even at the age that somebody would be in college, and I realize LeBron never went, but Michael certainly did, you could have a Nike contract, and Nike would pay you a lot of money. And the question immediately came up, does that forfeit your amateur status? And the NCAA said yes. So Michael Jordan could not have signed a contract with Nike until he graduated from North Carolina or decided that his time was up at North Carolina and he was moving on.
Len, let me just say one thing. For those who don't know, the NCAA is the National Collegiate Athletic Association, and that's the body that controlled sports for years and years and years. Many of us who were fans of college sports have had negative perspectives on the NCAA. In fact, my perspective is that if they could screw it up, they would screw it up. And in fact, their activities involving decisions to appeal to court decisions were part of the problem that's led to where we are today. And one other thing I want to mention to you is I first heard of you on a podcast called the Duke Basketball Report with Jason Evans and Samuel Wine, I believe his name is. And one of the times on that show, I heard someone recently named Ken Denard, who was a great Duke basketball player back my third year of law school. He was a freshman on the team that went to the NCAA tournament and lost in the finals to Kentucky against Jack Givens, et cetera. And he recently said that NIL, when he asked what that's all about, he said NIL stands for now it's legal. And I'd like you to comment, if you would, as you were talking before, Len, about how the third way was the way of the cash in the bag, how the NIL process now is trying to make things legal, although it's probably being a very imperfect legality.
Right. But what happened was it became very unpopular with the public that the athletes couldn't monetize their name, image, and likeness. The public, for whatever reason, and it makes some sense, thought that paying salaries to athletes sounded sort of tawdry. But for the athletes to make some money on the side, whether it was a little or a lot, was perfectly reasonable. And in fact, in California, a bill was passed providing that every university in California, all universities in California were prohibited from declaring athletes ineligible if because they had obtained name, image, and likeness money. The bill was passed in 2019. I helped the state senator who proposed the bill modify the bill, convince a majority of the state Senate and the state House to pass it, convince the governor to sign it, and put it into law. And the NCAA threatened to kick all the California schools out of the NCAA, a threat no one took very seriously. And shortly after the NIL bill passed, which was in 2019, about half of the states in the United States passed bills very similar to the California bill. So the NCAA was confronted with the reality that name, image, and likeness was with us. If 25 states say you can't kick kids out of school for taking money from Nike or taking money from the local car dealer to come over on Sunday afternoon and shake hands with his customers and make $500 a week or whatever it might be, anything from big money to small money. If you can't police that in 25 states, you can't police that in 50 states. You need to change their rules. At the same time, Ed O'Bannon, a former UCLA basketball star, had sued about name, image, and likeness. O'Bannon won his case, and so off we went to the world of name, image, and likeness. The problem was people started cheating. So when you hear people say, I hate name, image, and likeness, I hate NIL, NIL has ruined sports, which any of you who are sports fans have heard this. What they really mean is they hate people cheating about NIL. Because what would happen is the University of Oklahoma wanted a football player. The alumni got together and formed collectives, as they called them. The collectives put together money, lots of money, and the collectives asked the football coach who he wanted. And when he said he wanted a quarterback named Smith who was playing in Ohio, they went to see Smith and they said, we'll give you $250,000 a year to come to Oklahoma, and it'll be for your name, image, and likeness. No one asked about contracts for shoes, contracts for advertising, contracts for public appearances. It was all BS. There was no name, image, and likeness there. There was essentially what you would call salaries or bribes or payments or inducements, what have you. And that's why Kenny Denard is saying now it's legal. What Kenny Denard was saying was they used to slip people money at some of the schools some of the time, and now they give the people the money and they call it name, image, and likeness. But it isn't. It really isn't. I mean,
Len, can I interrupt 1 second there? Just
Yeah.
1 second. I want to distinguish name, image, and likeness to pay for play. And I will talk about since I'm a Dookie, the hated North Carolina Tar Heel Armando Bacot, who last year, if you saw the NCAA tournament, you'd see him in a lot of commercials for Taco Bell. And I, as a sports fan, I don't have a problem with any student, whether it be a singer or dancer, or actor, actress, whatever, or athlete, getting paid like Armando Bacot did for his appearance at Taco Bell. Where I get concerned is the pay for play access, which I think you're starting to get into with universities or with the collectives or some other entity paying players to say, if you go to UConn or Duke or UMass or whatever, we'll pay you certain monies. Can you distinguish the pay for play aspect, please?
Yeah. The pure concept of name, image, and likeness that was sought by Ed O'Bannon and was approved by the California legislature means you are getting paid because your name, your image, and your likeness is valuable. Again, Michael Jordan's name, image, and likeness is really valuable. He makes tons of money on shoes. You can make money on almost any product. You can make money by making public appearances, go and shake hands with people someplace. And all that money is legit. People make money by monetizing their social media accounts. There are young, attractive female athletes scattered around the country, gymnasts and others who are making a lot of money on their own without the help of any collectives or alumni or whatever, because they are popular or they've made themselves popular. And all that has been legitimized, but it's also at the same time, it's become a cover for slipping athletes money to go to a particular school. Again, let me go back to Cooper Flagg. Cooper Flagg could have chosen any college in the country, and he could have gotten a very large shoe contract with them. So he could have gone to school at Duke or Kansas or North Carolina or UConn, and he could have monetized his name, image, and likeness. But the universities have nothing to do with it. But when the universities get involved with it and say, come to North Carolina, come to Duke, come to Kansas, and we will arrange for you to get $1 million a year in what I now put quotes around it, name, image, and likeness, they really mean we'll give you $1 million. And maybe we'll find some contracts and we'll recoup half of it, but we're giving you $1 million. So it's pay for play. It's what you would call a salary, or again, what you would call a bribe. And what Ken Denard would say is now it's legal. It's become legal simply by people doing it and no one enforcing the rules to pay athletes whatever you want to pay them and call it name, image, and likeness.
Len, just to clarify one thing for you. A lot of people that watch this show may not know who Cooper Flagg is. I'm a Dookie, you're a Dookie. Cooper Flagg is already been named the ACC, that's the Duke Conference Player of the Year. He's probably the number 1 or 2 player in the country now, probably the first draft choice next year. And he came down to choosing apparently Duke or UConn. And he chose Duke. And I think what Len is saying is that he would have gotten whatever money he got, theoretically speaking, from Nike or wherever he got his endorsement money from the source, regardless of what school he went to. But there are, of course, some basketball teams that are Nike sneakers and the others use other sneakers. And so there's some interconnection. But Len, there's one positive NIL, I will say, and that is forgetting the Cooper Flaggs who are the best of the best. I want to go to Jeremy Roach, for example. Jeremy Roach played for 4 years for Duke, was a very good player, played in the Final Four in 2022. I was in New Orleans. I went and watched us get beat by Carolina, unfortunately. But the thing that's positive is that he might be someone who's on the cusp, no offense to him, of being a good NBA player, or maybe his best monetary years might be while he's now at Baylor. He went from Duke to Baylor for his 5th year. And there's a positive because some guys who may not, or ladies who might not have an opportunity to make as much money in the pros, have a chance with the NIL. And speaking of the women, right now the WNBA has a cap on what the ladies can be paid. And a lot, like Paige Becker from UConn, is making a lot more money now playing basketball at UConn than she would have in WNBA. Any comments about that, Len?
No, I think you're 100% correct. I mean, Baycott is another good example. Baycott was a pretty strong power forward or center in North Carolina, but the pros were not that enthusiastic about him. He wasn't quite tall enough. He didn't shoot quite well enough, and he spent 5 years at North Carolina making money off of NIL because the alumni were happy to pay him to stay at North Carolina for 5 years. He took them to the Final Four a couple of times. And those might be the largest paychecks, quote unquote, he's ever going to get. If the pros are right that he's going to be a G League player or a D League player, or he's going to have to play in Europe or play someplace else, he may never make that kind of money again. Now, for a superstar, it really doesn't matter that much. They're going to make a ton of money unless they get hurt, and they're going to go pro in 1 year. So it's one and done, and the money is kind of minor.
When I have,
Bob, it's also the case that very minor sport athletes are making money. There are athletes who are tennis players, golf players, track and field stars who are making $1,000 a year, $5,000 a year, $8,000 a year. Some of them are on partial scholarships or no scholarships. That's big money for them. That's maybe the difference between them going to college or not.
Len, I have my feet in both camps because I went to Yale undergraduate and Duke Law. Now Yale doesn't allow the extra year, and a lot of players from the Ivy League schools. In fact, we lost a player this year who's a star on Michigan named Danny Wolf, who as a sophomore transferred to Michigan, where he's getting whatever money he's getting. I always developed the love to watch a guy develop over 4 years. Grayson Allen at Duke, who was a star in the 2015 championship game and helped Duke win that game, stayed 4 years. And it's fun to watch guys develop. It's not as much fun to watch, as far as I'm concerned, the one and done. But the NIL possibilities, you may get guys, for example, this year's Duke team has a couple of guys. One guy, they call him Slim, Isaiah Evans, who's projected to be a top 40 pick in the draft. He'll make some money. I mean, good money, but not compared to the other star athletes. But Duke, by the way, could pay him, or through some collective or some NIL deal, whatever. It really wouldn't be Duke paying it. He can get enough money to say, you know what, I'll make more money as my sophomore year at Duke, or someone at UConn, the same thing, than if I go pro now. So there are some positive benefits. Len, you mentioned the phrase collectives. I'd like you to just talk about what is a collective in this genre.
Sure. Everybody knows that there are people who are called boosters of universities that have substantial sports program. They've had them at Alabama and Texas and North Carolina and UCLA forever. And boosters are people with some money who like sports and are usually alumni of the university, once in a while not. And they, in the past, would write checks to the athletic department. They would support the athletic department of their school to the tune of $1,000 a year, $10,000 a year, $100,000 a year, $1 million. There are places where if you go see a basketball game, there are plaques on the wall thanking people for giving them $1 million to help build the new building. Those people have always existed. They have never given money to the athletes, as far as we know, except under the table possibly, but mostly not. And what happened when name, image, and likeness was legitimized by the California laws and in the other laws in the O'Bannon case is these same people got together and had another meeting like the meetings they always have. And they said, hey, we can take advantage of this. Let's put our money together. And instead of giving it to the athletic department, let's give it to the best basketball and football players. And, you know, at different schools, maybe different sports. Oklahoma likes wrestling. Let's get all the best wrestlers. Just take the money we have and use it to buy the players. And if anybody in the room said, I don't think we can do that, they said, no, we'll just call it name, image, and likeness. Tell them we're paying them $500,000 a year to come to Oklahoma, and we then own their name, image, and likeness, and we will make the money back on contracts. We don't have to, but we'll try. And it's created a lot of havoc because some of these people, they stop paying the kid if the kid can't play as well as they think he's going to play, or they get distracted by another kid. So it's so different from a salary. It's so different from a scholarship. There are no rules. It's called the Wild, Wild West. And the boosters have an inflated sense of their own importance to the university's athletic department. And they want to say, you know, UConn won the national championship because I got them John Jones and I gave them $500,000. So it's unfortunate.
We only have 2 minutes. We only have 2 minutes left in this show, and Len has been courteous enough to say he's going to do at least 1 or 2 more shows with me on this topic. And there's a big lawsuit that's going to be settled perhaps in the near future, which we'll talk about. In fact, we may even have a retired judge who may join us as well. But in the last 2 minutes we have, Len, can you just give me 1 minute, if you can, of 2 schools, I believe it was Northwestern and Dartmouth, talked about getting unionization of the players, and it didn't really go forward well so far. Just briefly speaking, just give us a little bit of a taste of unionization, how that might play into the whole situation of NIL.
Well, sure. In the limited time, the easiest thing to say is that the colleges are tearing their hair out over how wild everything is. And some people say you need a system, you need a collective bargaining agreement, you need the same things that the NFL, the NBA, and MLB have. You need rules. And then you can enforce your contracts and keep your players, and they don't jump from school to school or team to team. So the only way to have a collective bargaining agreement is to have a union. And so there has been some talk from the students and some talk from the schools, first the students, now the schools, that unions would be useful because we could have uniform national rules rather than the wild, wild west. I think that's as far as we get today, other than to say that there is one huge lawsuit called Grant House versus NCAA, which is attempting also to rationalize what's going on in the world.
And we'll get to that the next time.
Without a union.
Len, I just want to say one last thing for today's show. And I've been honored to have you on the show. I truly have been, because not only are we both big Duke basketball fans and college basketball fans and sports fans, but your knowledge is so very, very important. My biggest concern, which we'll talk about in the next episode that we have, is that the so-called minor sports, cross country, field hockey, I'm just picking those 2 for sake of argument, those sports could be terribly adversely impacted by all this NIL situation, because schools might be getting into the profit motive and other things. But we'll talk about that, Len, the next time. Len, you have been such a pro, and I really appreciate your time and effort. This has been Bob Opotzner with the great Len Simon saying goodbye for the Bobby O Show. Thank you very much.
Thank you, Bob.